Good morning, everyone, and welcome to today's webinar on how to get the best environmental deal in property transactions. My name is Lucy Quick, and I'm the Digital Marketing Manager here at InfoTrack. I am joined today by Keith Davidson from ELM Law. Keith is an environmental law specialist and will be sharing a wealth of knowledge regarding environmental insurance, law society requirements, tips, reports, and more. Before we begin the webinar, which should take no longer than 45 minutes, I'd like to draw your attention to the box on the webinar software that allows you to ask questions as we go through. Type them here and we'll answer any questions at the end of the session. I will now hand over to Keith to present. Thank you.
Thank you, Lucy. Hello, everybody. I hope you're all having a good morning despite the horrible weather out there. A big thank you to Lucy Bronwyn for organising this. It's a really impressive attendee list. So I better make it good. Now, ELM Law is a specialist environmental law firm, and I provide support to real estate and corporate lawyers when high-risk environmental issues arise in transactions. And with environmental issues, thankfully for me, they tend to be pretty much all high risk. Now, the legal principles are the same, whether you're dealing with a large chemical site or if it's just a normal property transaction where a desktop reveals a former landfill or a petrol filling station. So the aim of this seminar is to give you practical tips where you can highlight the key risks to your client and know when to put in the essential protections. And as it says, the overall mission is to get the best environmental position for your clients. Now, the first half of the seminar will really be looking at the kind of due diligence side. So starting at the basics of what the Law Society expects us all to do, through to highlighting the key liability regimes and some specific things that keep cropping up time and time again in transactions, like landfills and groundwater issues. The second half, which will be of the seminar slightly shorter, will be the kind of practical things to protect your clients. So looking at the principles of what happens in sale contract environmental provisions, and then finishing with environmental insurance, in particular, the difference between the contaminated land indemnity insurance that you may all have come across and the more expensive sort of site pollution policies. Now, looking at this map of England and Wales, you'll see there's contamination all over the place. You could have similar ones for flooding or for coal mining or other mining risks. The fact is, you will, on a daily basis, often, definitely on a weekly basis, come across contaminated land issues. So you need to know exactly when something is serious. Now, the Law Society have picked this up. So back from 2002, they issued what they called a warning card. It's now called the practice note. And it says you should really do three things. Order your desktop search, which you'll do, of course. But the other two aren't done in every transaction. One is actually explain the liability implications to your client. And I can understand a lot of property lawyers mightn't want to sort of step into that. And the last one is actually recommend appropriate protections. So one of my slides will be, what do you do when you receive a high risk desktop report? Now, there's a bit of a threat really for property lawyers because there's professional negligence risks if you don't follow the Law Society warning card. Now, this case that Bird and Bird were involved with, unfortunately for them, was to do with a residential transaction where the property lawyer got one of these planning reports. If you've ever seen one of these planning reports, you know, there could be about 80 pages of just lots and lots of information, and you can't be expected to read it all. one of the entries said that there was a 6-story new build school 300 meters away, and the lawyer didn't basically warn the client about that. Bird and Bird understandably said, surely we can't be expected to highlight all of this information, but it went to the Court of Appeal and they said there's a duty to inform your client of its content. So the first big thing for every law firm is, how do you actually handle that? Now, property professionals, support lawyers get very excited about this, and your report on title might already have lots of sort of disclaimers saying, we recommend your own and technical consultant looks at this. There's gaps with desktop reports, etc. You do need to put in those disclaimers, but at the same time, you should, getting back to that first thing, getting the best environmental position for your client, they actually expect to have knowledge of some of the risks. So you have to find a happy medium. Right, so the first thing I'm going to look at are the key environmental liability regimes. Now, this slide shows pretty much everything that can go wrong if you have a contaminated site. Now, on the left column, you'll see contaminated land regime quite near the bottom. That's because it's meant to be the regime of last resort. You've also had the government taking away funding for contaminated land investigations. So part of my practice 10 years ago was being involved in these is all tied to the standards of cleanup under contaminated land, and pretty much all of your contracts, etc., will have reference to Part 2A. So I'll explain the liability regimes there. The ones in this kind of mustardy color are the ones in practice that get clients most excited about. So you need to always warn them about nuisance claims for offsite migration. And the contractual column there, if you have an indemnity in a sale contract, that is often the trigger when clients say, oh crikey, we need to do something. Or if you have a lease indemnity that usually doesn't have a cap or a time scale, you need to basically do something. And then the last one, I'm going to talk about landfill tax liabilities, because this is really causing a ripple in the waste management industry. So you should know the contaminated land liability rules already. Very simple. If a site is targeted as potential contaminated land, you have the Class A causers, that's the original polluters, but it can be wider, like developers, but also a knowing permitter. A knowing permitter has got the same legal status as a Class A causer. That's very, very important. Now, once a client, say your seller client, is a Class A person, they're stuck with that liability forever unless they can successfully transfer it. Now, in sale contracts with things like the sold with information task, it allows a Class A causer, knowing permitter, who's a seller, to legally transfer all of that liability onto the poor innocent buyer. So if you're a buyer, not only can you be liable as an owner, but you take on all the liabilities of the seller. A few other things that come up, you might need to advise your client. One is an owner, that's an innocent owner who's not a Class A person, is not liable for water pollution. Now, flipping that statement on its the other way around is, if an owner becomes a knowing permitter, say, for example, getting an environmental report, they do become liable for water pollution. So when you're dealing with contaminated land where cleanup liabilities can be over £1 million for groundwater contamination. These are really important principles, and they're often dealt with just with a few lines in a sale contract. And just to emphasize that point, many law firms take a different approach on how to protect your client with the sale contract. I actually wrote the precedents for LexisNexis on this, so I'm sure you can all have a look at that version. But it's really important to cover not just the contaminated land regime, but all environmental liabilities, because you don't really know what's going to come up and bite you. The last point is it's very easy for a buyer or developer, sometimes even a tenant, to become a knowing permitter. If they're allowed to do intrusive ground investigations, or if you get an environmental report, as I said at the start, you have the same legal status as the big bad polluter. Now, I mentioned that Part 2A had ground to a halt. That's not entirely true. There's local authorities still threaten to take action. So they mightn't have the money to actually do phase 2 investigations themselves, but the contaminated land officer can send letters to the seller, buyer, previous occupiers, anybody that they can find as potentially liable, and say, what are you going to do about it? We believe this is a contaminated site. Now, this picture, I dealt with a site in Chester, acting for a developer who built a housing estate. Now, you'll see the waste ground at the end. That was near a railway line. And when the railway line was being constructed, lots of old crap was put into the ground. Railway-related waste that can sometimes be quite hazardous. That migrated through the groundwater and then into pipes that actually were detected within people's kitchens. So, and there was an explosion risk. So that that was categorized as unacceptable harm, and Part 2A proceedings were taken. Now, if I'm going to fly through the next 4 or 5 slides, because I don't want to bore you with the law, but if, in addition to the contaminated land regime, there's lots of other environmental liability regimes that regulators or third parties can press the go button on. The main one is the anti-pollution works regime. So if I look, generally when you have a water pollution issue, the Environment Agency take over if it's contaminated land proceedings, but they can also tactically just use this other piece of legislation, Water Resources Act, that doesn't have all of these exclusion tests, and it doesn't have a standard of cleanup, and they can just threaten to serve a works notice. So if you have, for example, environmental insurance, it needs to cover a works notice as well as a remediation notice. There's a relatively new environmental damage regime. I mean, 2015 isn't new, but compared to some of the other legislation it is, and that this changes the whole principle of your tactics and transactions, because often it's best tactics not to do any phase 2, not to tell regulators. But if you have an operational liability site, i.e. you store chemicals, you have risks to groundwater, you have an environmental permit, you have a legal obligation to tell the client, to tell regulators, and a legal obligation to immediately take preventative steps. So you should look in your desktop, there's often a section called operational liabilities, and check if it says there's an environmental damage regime risk site, you should tell the client, because it changes the client's obligations. Now, the new kid on the block is unlawfully deposited waste. That's obviously been done forever and a day, but there's 2 new pieces of legislation. One came in 2 years ago. Actually, both came in 2018. One was to do with landfill tax, and the other one just basically strengthened existing legislation. To keep it simple, you will often have unlawfully deposited waste on a site. That can mean 3 things: fly-tipped waste that you've no control over, a development site where the developer kind of digs up contaminated soil, keeps it on the site to reuse. Now, you've got this thing called CLARE verification. It's the Development Industry Code of Practice. If you don't have the correct paperwork for storing that waste, that waste is unlawfully deposited waste, and you can actually be clobbered with landfill tax liabilities. That's one if you're a development lawyer out there. The other one is if you have a permit, and permits have very specific conditions. And with waste conditions, you can often store waste in excess of the amounts allowed in your permit. Again, that's classified as unlawfully deposited waste. The implications are the Environment Agency can ask both the landlord and the tenant to clean up. So this is a big one to warn your landlord clients. They can also serve restriction notices and orders to prevent access to your own property. And you can be clobbered by HMRC for landfill tax and additional civil penalties. And I've been involved in these. It can really change cleanup liabilities from, the £50,000 type stuff to, hundreds of thousands of pounds. So it really has made a big difference. And the last thing is third-party claims. So if a desktop suggests that the groundwater is high risk, more sensitive, or there's surface water close by, or there's residential houses close by, you need to warn your client that there could be private nuisance claims. And then if you're dealing with developers, my first job was at Eversheds, and the development lawyer never got the environment team involved. And I always thought that was quite strange. And the reason for it was developers have their own technical environmental consultants that they often have used for years. And they say, yeah, they'll deal with planning, they'll satisfy the conditions, we've got environmental sorted. That is so much, that is not correct. Because basically, the phase 2 reports will often miss something. And in every brownfield development project, you always need to think who is liable for on-site contamination that has been missed. That's called residual contamination, or off-site migration. And it's often the actual development activities that create the risk. So you could have a messy site for 200 years, there's no liability. Then these guys come along, drill holes, mobilize the ground, and a plume of contamination migrates off-site, and that creates the liability. So if you're acting for a developer, it's actually, they take on most of the risks, and you need to really advise them who's liable. So that was the due diligence part. Now, what do you do to protect yourself part? And the first thing is look at your desktop. So I'm going to look at some of the higher risks like landfill and groundwater. I'd always advise you to actually read the desktop in detail. There's an awful lot of very good information, particularly about permits. Now, the client really wants to know, how much will it cost? There's this old guidance, HCA guidance, on dereliction, demolition, and remediation costs. It's actually quite good if you get a copy of this, because clients will say, what's the worst case scenario? This guidance looks at groundwater sensitivity via type of historic use. And for example, the minimum bit would be 50k per hectare, going up to over £1.5 million for water remediation per hectare. So it can often be over £10 million for groundwater cleanup. Flooding, of course, is a massive risk now. This was a flood in a housing estate in Wales, a Taylor Wimpey site. It was built on the floodplain. They put up flood defences, but the flood defences didn't work. So not very good for those homeowners. Now, landfills are probably the highest risk issue on any of your transactions. And if you do have a landfill, particularly within, say, 100 meters, you need to raise regulatory inquiries and ask about all of these questions. It's a big difference if local authorities will often have monitoring reports and will tell you if a license has been surrendered or not. To put this into context, a landfill operator often has to do monitoring for 50 years to satisfy the Environment Agency that there's no longer any risks to the environment. So if this pops up in your site, there's a good chance there are risks. The other big one is petrol filling stations. There's often 2 or 3. In the history of a petrol filling station, there might be 2 or 3 tank farms underneath, with maybe 6 or so tanks. Now, the old ones, single line tanks, were just prone to leaking. And of course, they're all closer to the groundwater. So you really need to advise who's liable for that. Permits is one that is really a risk. It's a professional negligence risk, I think, because nothing will peeve off a client more than you suddenly telling them that their planning application isn't going to proceed. Now, in this particular scenario, the HCA had a planning application, did desktops for lots of portfolio of sites, and all of them came back as passed. Now, many property lawyers would send the reports and say, there you go, there's your past reports. Now, I was actually acting at Panoni at the time, and the head of property team, who's very good, read the report, and there was a bit about the planning. It's in the permit section to say it used to be a composting site. You should ask your surveyor to comment. Luckily, he put in that advice, because when the HCA put the planning application, there was an impediment for, you basically couldn't construct within 250 meters from this permitted site, which was a composting site. So they could have brought a claim against the law firm if the property lawyer had put in that warning. And time again, I come across vehicle wash bays that do not have a permit. They need a permit, and in some situations, you'd have to make a money laundering reporting officer notification, because it's a breach of law if people don't have them. Now, finally on this, it's the groundwater liabilities. Now, I harp on about the difference between soil cleanup that could be 5-10 grand and groundwater remediation, which is over $1 million. Now, this doesn't look like a big nasty site, but it used to be a chemical site. And the contamination migrated 20 kilometers because it was a chalk aquifer. So that is basically as bad as it can get. That was over £16 million cleanup over a 10-year period. So what do you do about it? You get a desktop, first of all. Make sure it's a good one. You can order whatever ones you normally use. Landmark, Groundwater, there's a few other providers. I personally recommend the Groundwater Review as your normal one. There's a cheaper one called the Groundwater Screening if it's not as high risk. And the new kit in the block's the Geo Risk. So you can get a Con 29 and non-mining risks in the one report. I think Groundwater give training on that. Now, if your desktop comes back medium or medium high, it's medium high or high. So the top 2 risk things, they will recommend further action, or it's not suitable for lending. So you have to do something. What do you do? Well, you can cut and paste this table to give options to your client. Regulatory inquiries are great, particularly if you have a landfill, but you need up to 21 days to get the response. So sometimes you don't have that amount of time in the transaction. So other options are you can get the Groundwater Landmark to do a phase 1 or your own consultants, or you can get insurance. Finally, if time is an issue and if you want to satisfy a bank, if it's a say Manchester City Centre, high risk because it used to be industrial sites, but it's actually low risk of enforcement. You could get a desktop that says not suitable for lending, but then you can get an environmental legal opinion that says it is suitable for lending. So your sale contract will have clauses to transfer liability from a seller to a buyer, or sometimes the buyer will try and put it onto the seller. Personally, I get very frustrated if the principles haven't been agreed at the start, because you can end up redrafting these things 3 or 4 times. So try and get it in at the heads of term stage if you want to successfully transfer liability, would be my tip. The principle that I said at the start with the contaminated land regime is if your seller client had any control of storage tanks, they could be a causer. If they have ever seen a geotechnical report or a phase 2 report, they could be a knowing permitter. So if there's any risk of your seller client being one of those 2 things, you have to put in these clauses. If there's no risk, there's no need for any clauses. Now, once the seller has one of these Class A liabilities, it remains with them after the sale. So I act for a lot of chemical companies, and their big thing is they like to control their liability. They're big bad polluters. They have got accounting provisions that has lots of money every year just to keep the regulators at bay. So what they try to do is just monitor contamination to say, oh, it's not getting worse. So if the Environment Agency knocks on their door, even with the messiest sites, they have no liability. Now, as soon as they sell their site, a developer mobilizes the chemical contamination, and then houses get built, and that makes it more sensitive for regulatory or third-party action. And this liability bounces back to the seller. So there's ways to transfer. The ones on the left-hand side of this, that what you come across all the time, sold with information agreement on liabilities. And I'll explain this in a minute, but that only transfers liability for the contaminated land regime. It doesn't deal with all the other liabilities. So if you're acting for the seller and you want a clean break, you need an environmental indemnity. Sold with information, which will be in all of your transactions, can actually apply if the contract is silent, if the buyer is a large commercial organization, because there's 2 ways for this test to work. One is you give permission to a buyer who's a large commercial organization or public body. The second is if the buyer is not, you will have to provide an actual contaminated land report. As I say, the legal effect is the seller is legally excluded. The buyer takes on the seller's liability for Part 2A only. Agreements on liabilities is where I have the most fun, because you can tactically use them as an indemnity. If you put in the phrase transfer all liabilities, not just Part 2A, it can be an indemnity with no cap or time limit. So really keep an eye out for those in your sale contracts, your leases, your development agreements. And this is the magic phrase, accept all liabilities under environmental law. Again, if this is in your contract and you have to explain the implications to your client, there's this list. These are all the things that can come and bite them. So, looking at environmental insurance, when I first practiced environmental law 25 years ago, environmental insurance was only offered by 1 or 2 underwriters. It was a big thing in America, but the premiums were very high. So the first policy I looked at was £450,000. It was for a development site where the main contaminant was hydrocarbons, and the insurance policy excluded hydrocarbons. So I thought, what a load, what a waste of money. And I wasn't a great fan of environmental insurance for a while. I was burnt by that experience. But now, all these years later, I use it in nearly every transaction. So what has changed? Firstly, the policies are a lot cheaper. You can get indemnity policies for £1,000. You can get good policies for 40 grand. And there's a lot of competition. So there's maybe 10 or 15 underwriters. And if you go to a good environmental broker, you will really see a big difference in the premiums. So they should often approach 3 or 4 different underwriters. Now, when is it needed? The big one that I come across time and time again is one party has to give an indemnity. So as a property lawyer, you highlight in your report and title, we have to give this indemnity. We don't really know what contamination's down there. The desktop says it's high risk. Are you comfortable with that? The client says, of course I'm not. Protect me. And the only protection available is insurance. An environmental insurance policy, the big drawback is it only lasts for 10 years. Sometimes you can get up to 13 or 15, but it's quite an expensive way of protecting yourself. The other ones are if a seller wants a clean break, like a chemical company would always look at environmental insurance, in my opinion. And if you have development work, you need contractor pollution liability insurance. Now, since these policies are more important, it's important to get the correct terminology. Now, when someone talks about an indemnity policy, the easiest way to explain that, it's the cheapy one. It's really just for field desktop reports. Some of them only cover Part 2A, that's the contaminated land regime. That's why it's so cheap. Some of them are widened to Water Resources Act. So you should always go for the Water Resources Act one. The good thing about them, well, there's 2 good things. One is they're as cheap as chips. And the other one is they can last for 25, sometimes up to 30 years. So that's great if you're only giving, say, exposure in a transaction to contaminated land liabilities. That is the one for you. If, however, there's risks of water pollution legislation being triggered or civil claims, you need a proper policy called a site pollution policy. The beauty of these things is it also ensures the indemnity. So going back to that box of all the things that can go wrong, liabilities, it covers it all. The downside is you have to pay up to the deductible. It only lasts for 10 years max. It doesn't cover fines. It has exclusions for redevelopment and voluntary site investigations. So if you deal with the development side, if you're a development lawyer, you will need a combination of a site pollution policy and a contractor pollution policy, because CPL covers the main risk, which is actually disturbing the existing contamination. The creature from the Great Lagoon. Now, I'll give 3 very quick case studies bringing all this together of how it pops up in a transaction. Now, this one has been rumbling on for 5 years, and I've been acting for the University of Birmingham, who bought a remediated site from Birmingham City Council. They then granted a long lease to Bruntwood. The transaction's gone through. They're building a life sciences park. It's great for the region. However, there was a whole humdig hoo-ha of who's liable for contamination. So first thing, here's a remediated site. Here's all of our reports and industry standard warranties. Report to your client. That's all you're getting, was basically what the council was saying. So I said to our client, let's do a health check. Has it been cleaned up? You read the report. No, only 5% has been remediated. What was the name of the site? Oh, Battery Park. I say it's quite heavy contamination. Groundwater hadn't been touched at all, and it was polluted. Has the planning been discharged? That's quite a big one if you're acting for a buyer. No, it was only partially discharged, so we had to wait. Then you will come across the indemnity discussion in almost every contaminated land transaction. What you tend to find is if you, despite one client saying, this is our position, I want full release of liabilities or whatever, you can normally find a happy medium. If you're acting for a buyer or developer, you want to exclude pre-completion migration, because effectively you've no control over that and it's not fair. At the end of that transaction, the university said to the law firm, is this suitable for purchase? And actually, only if you had insurance. So they needed site pollution and CPL. Here's one that looks lower risk. There's a retail park where you go to buy your new toaster at Curry's, but it was a pension fund seller and buyer, both risk adverse. I wasn't brought in till the 11th hour, which is quite typical. And what had happened, the report said there was a former landfill and petrol filling station under the retail park. There was a list of 30 reports. I was only sent the overview one. And that said that all of the units had gas alarms, which basically means there's an explosion risk. So you have to have protection. Now, the seller took out a 10-year policy, and they said to the buyer, there's 3 years left of this policy. It can be assigned to you. So you take the rest of the policy, but you give us an indemnity because we're a pension fund and we want a clean break. The buyer obviously wasn't so keen on that, but had to give the indemnity. When we looked at the policy, our advice was it was invalid because the seller had basically breached the redevelopment exclusion. So we got a new policy. We managed to get it for 13 years. And for this high risk site, you're talking £150,000 type premium. But in the context of a deal that's like 10 million quid, they weren't fazed at all by that. The last case study, just before we hand over for questions, is something that we come across more often, lower risk. So a buyer expects a site to be contaminated. The seller sent a phase 2 that said, sorry, a phase 1 report says this is low risk. They then wanted to transfer all the liabilities to the buyer. Now, when we read the report, tucked in on page 14 or something, it said, oh, there was a EA caution. Now, caution means they've breached environmental law, they've been slapped on the wrists. If they do it again, they go to court, you can have personal fines. So we got a consultant to look to see how good this lagoon was. It was okay. That only cost 800 quid, but we still got a 5-year policy that only cost £40,000. The deal was done, the client was happy. So that leaves us 5 minutes for questions. And I think, Lucy, if you take over now and see if anyone's sent in any questions.
Perfect. Thank you, Keith. Thank you for your time today. And I hope everyone's found this session informative and engaging. We do have a couple of questions to get through. So, Keith, regarding former landfill sites, what are the risks if I'm acting for a client which is taking a lease of part of a site which is within 250 metres of, but not on the landfill site? Surely any liability would sit with my client's landlord rather than my client.
Right. Well, the first question would be, how long is that lease? Now, if it's a lease under 21 years, the tenant is legally excluded from contaminated land liabilities. If it's a long lease, they effectively you're treated like the owner. An owner is liable if contamination comes across and you fail to do something about it and become a knowing permitter. So if you're aware of contamination, or if you do a phase 2 report, you can pick up liability as a class A person. You're right to say the liability does start with, should be with the landfill operator. If it's a large landfill that are very well run, it's actually probably the lowest risks. What you need to worry about if it's one of these old landfills where it hasn't been cleaned up properly, etc. If the landfill operator is still around and has funds, that should be the end of the matter. If there's any threat to that, that's a bit more dangerous. Finally, if you're if it's a local authority landfill, there was a case about 4 years ago that basically said if there's reorganization of the land of that local authority, they might not actually be targeted as the original polluter. So that was the Powyn case. I can't pronounce it, but it was a Welsh case. You might want to look at that. But it's the same principles: raise inquiries, but do not do a phase 2. And protect yourself if you can with an indemnity. In a lease, you should always have a tenant protection clause.
Perfect, thank you. And second question, if your client does a phase 2 investigation, does it increase the risk of becoming a knowing permitter?
It most certainly does. So if you just have a desktop that just says historic uses, etc., maybe a pollution incident, that doesn't, to satisfy the test of knowing permitter, you must have knowledge of actual contaminants. So you will only get that from a phase 2, a geotechnical, sometimes a phase 1 if you see a spill. Now, so if you do a phase 2 report, the implications are from having no liability or just this owner liability, you're now elevated to a potential Class A person, not just for contaminated land regime, but also for water pollution liability. That liability then stays with you even after you sell the site. So you have to have protections. So it's often best not to do a phase 2. Of course, you will need to do it for planning, or if it's a large transaction where you need some decent information for an indemnity cap. But often, as I say, don't do it.
Okay, thank you. And then we've got one final question. When is a tenant legally liable under the contaminated land regime?
Right, sorry, I didn't cover that earlier. A tenant is legally excluded as owner. So you have your Class A people first, and then Class B. Now, the owner is the Class B, and it says the tenant is legally excluded. However, there's 2 or 3 ways that changes. One is if the landlord goes bust, the tenant becomes the only Class B person, and then they take on this liability. Secondly, will be if it's a long lease over 21 years, the tenant is treated like an owner. So sold with information in a contract can pass on the landlord's liability on the grant of a lease. The other practical thing to mention is a tenant can become a knowing permitter by doing its own investigations if it's allowed to disturb the land. But finally, in pretty much every lease, you will have a covenant for a tenant to comply with statutory requirements. Now, what that means is if the historic polluters can't be found, the landlord would be legally liable, but they then go to the lease, and if they have to do any site investigations, legal fees, you name it, they can pass on some of the costs, certainly the cleanup costs, to the tenant under that clause. So as I said earlier, you always need the tenant protection clause, but there's games to play with that too. I hope that answered your question.
Thank you. We've got another question that's just come through. Can drilling piles for a new build create pollution where there was otherwise no pollution? And can this be overlooked from a desktop study?
Yes. So drilling piles, there's 2 risks. One is you mobilize existing, the sleeping giant that's been there for years, and that creates a pathway, and the pollution goes off site or moves to another part of the site. The second one is actually these machines can have oil leaks themselves. I've dealt with a transaction where the environmental consultant actually spilt oil into a borehole. So it's normally a license to enter that deals with this. It's very important to have an indemnity to do with any of this sort of environmental investigations or remediation. The second part of your question was about a desktop. A desktop, whilst it tells you loads of interesting information, it'll tell you nothing about actual contamination. So if a client really needs to know whether for planning or an indemnity or whatever, or they're very risk adverse, do we really want to know what contamination is there? You need to do the phase 2. But as I said, you need to warn your client that it can increase the liability risks.
Thank you very much, Keith. And if you have any other questions about any of the content that you've seen today, please feel free to reach out to us. You can also contact your account manager for more information about environmental reports available through InfoTrack. I'd like to thank you all for joining us and look forward to welcoming you to another webinar soon. All that's left to say is I hope you all have a lovely rest of your day. Thank you.